this section of the media law lecture, we're going to address the torts of defamation of character and invasion of privacy. The law of defamation protects a person's reputation and good name against communications that are false and derogatory. Defamation consists of two torts, libel and slander. The main difference between the two is the form in which the defamation occurs. Libel consists of any defamation that can be seen, most typically in writing, whereas slander consists of an oral defamatory communication. The elements of libel and slander are nearly identical to one another. Here's a list of some of the court cases that we'll be going over in this lecture related to libel and privacy torts. When you see the acronym SCOTUS, that stands for the Supreme Court of the United States. You can find more detailed information about each of these cases in Chapter 5 in the Reed Posada Study Guide. A tort is a civil wrong that's done in a common law jurisdiction, and it's basically when someone is not very nice to someone else and there's significant loss or harm to that person, either physically or to their reputation. Just some terminology that you're going to hear that I want to make sure you're familiar with is when you hear the term plaintiff and defendant, in a tort situation, the plaintiff is the person who initiates the lawsuit, who actually will win the case. And if they win, they get what's called damages, which would generally be a determined amount of money that's set by the court or by a jury if it's that type of trial. It can also be settled outside of court, and that it means before it actually goes to trial, the two parties involved will agree on some type of settlement, and avoid it having to go through the court system. Defamation law is actually structured by the federal defamation standards, and it's closely tied to the First Amendment. In addition to the federal statute, each state has their own set of slander and libel laws. But for this course, we're just going to touch on the top layer of libel. Libel and slander are both defamation of one's character. The definition of defamation is when one's falsely accused with malicious intent and the person's good name and reputation are under attack. Libel is when that statement is written or published, and slander is when it's spoken or broadcast. Here's an illustration that helps perhaps define which medium would be considered libel and which would be considered slander. So for example, if you posted something on Facebook that was determined to be a legitimate defamation of character, in other words, harmful enough of a statement that would damage someone's reputation, and you posted it on Facebook, that would be libel. Whereas if you said it perhaps at a party or something like that where enough people heard it, it could be determined to be slander. The first of the four elements of libel is defamation, and this, when we're talking about this in the media, it generally occurs when the journalist is careless, they use exaggerated writing, they don't adequately fact check, or they don't talk directly with the subject or the subjects involved. Defamation itself is defined as a false intentional statement of fact that injures a person's reputation, but it's far more than that. It means someone's was fired or suspended from their job, so they had a loss in earnings. It could have been their reputation in business. That's actually called trade libel. It can be their exposed hatred, ridicule, or contempt, or it causes them to be shunned from the social culture that they're within. Defamation's not someone being mean. Being mean is not considered defamatory. It's considered opinion. And in a joke, I put here, unless you're accusing someone of being promiscuous, in which case you better be able to prove that. Especially if you're accusing them of prostitution, specifically, as that is against the law, which is the next bullet point. You don't ever want to make an assertion of fact that someone's breaking the law. Again, with journalists, using the term allegedly does not protect them against being sued for libel. One of my favorite comedians is Chelsea Handler. I used to love to watch Chelsea lately, but now I just follow her on Twitter. But her two favorite things on Twitter is she will mock someone's tattoos and she loves to mock other women's breasts. Yes, it's mean, it's cruel. Some don't find it funny, but she's not harming their reputation. That's not considered defamation. So let's test this to explain it a little better. Here's a more specific example. So the local high school football team has been state champs for decades, and suddenly they stop winning games. If a disappointed parent posts on Facebook, maybe if we had a better coach, we would be champs again. That's opinion, that's not defamatory. But if the same parent posts, maybe if the coach wasn't a drug dealer who sells crack and he's high all the time, we would be champs again. That's definitively defamatory libel. So, how would you test that? First, if it's a false statement and the coach can prove he's neither a drug dealer nor a crack user, because number one, that's illegal, and it injures his reputation enough he gets suspended or fired while they investigate. Or worse yet, people suddenly start throwing bricks through his home's picture window. Yes, he could definitely initiate a suit for libel. The second element is identification, which means the person can be identified by their name or any other information that could sufficiently identify who they are. It can be from just their name, it can be their face, it could be any other description of them. If the subject's identity's been disguised enough so that no one can reasonably make an identification, and the subject doesn't resemble some third party who would then have cause for complaint, then the person probably is the person probably can't be sufficiently identified. There's also something called group libel where individuals can be defamed, but groups of people can't be. The key question is whether a statement about a group can reasonably be interpreted to refer to a specific individual in the group. There's no hard rule, but several courts have indicated that individual members of a group larger than 25 will have a really difficult time proving that they've suffered individual harm. On the other hand, individuals in a smaller group might be able to claim that their reputation has been damaged. For example, the generic statement, the tennis team is being investigated for substance abuse, that's published in a local paper, could subject that publication to a libel suit if the team consisted of just 12 members. The third element is publication. It must be in print or otherwise published. It could be as simple as an email as long as two or more people saw it. The last would be fault or negligence or actual malice, and this is going to be explained a lot more in depth. There's actually two levels of fault. You have a private individual versus a public official or a public figure. A private person only has to prove negligence, whereas a public official or a public figure has to prove actual malice. There's a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he can prove the statement was made with actual malice. Again, that's with knowledge that it was false or with reckless disregard of whether it was false or not. In other words, they didn't care it wasn't true, they published it anyways, and the person can prove that they knew it was false. Who's defined as a public official and who is defined as a public figure? A public official would be one of these bullet points, someone who has responsibility to create policy, they work for the government, they work for the state. Their position invites scrutiny, in other words, criticism from other people, and it's generally someone who's elected or appointed to a position. A public figure would be someone like a celebrity, a actor, musician, again, someone who invites public scrutiny. There's four defenses in a libel case. The first and the most powerful is what the person is being accused of. Is it true? The judge will usually ask the defendant and the plaintiff that, and they'll ask for proof. The second would be privilege. meaning that it's public record, for example. It's a fair and accurate account of what actually occurred. Public records would be things like police reports, court records, meeting minutes, things like that. The last two kind of sometimes are combined into one, fair comment and criticism. People have a right to state an opinion, but they're not making an opinion of fact. However, if a person's in the public light, they're generally open to scrutiny or critique by the media, and they accept that's sort of part of the job.
The right to criticize political leaders and governmental officials is a fundamental principle of democratic government. It helps keep officials from abusing power. It helps inform citizens so that they can go to the polls and vote for candidates who best represent their views. It provides a check, perhaps an essential one, on government power. But what if the press prints falsehoods? What if it prints lies that unfairly hurt a person's reputation? What if it sets out to destroy a candidate or an office holder? Should it have a protected constitutional right to do these things? Does it? These are the issues the Supreme Court addressed in 1964 in New York Times v. Sullivan. But before discussing the case, we need to recall a bit of background. The First Amendment to the United States Constitution states in part, "Congress shall make no law abridging the freedom of speech or of the press." Now, despite this language about no law, the Supreme Court has never interpreted the First Amendment literally. For example, we can't publish material that gives away state secrets. We can't publish the location of troop ships in a war. We can't publish material that leads to committing fraud. But can we publish material critical of the government and governmental officials? In the 18th century, when the U.S. Constitution was drafted, the answer was generally no. The accepted practice dealing with speech critical of the government came under the doctrine of seditious libel. And seditious libel made it a crime to criticize the government, regardless of one's intent or even the truth of the criticism. Criticism of the government, even if truthful and correct, could be punished. The notion here was that criticism weakened the government. By 1776, however, Sir William Blackstone, the great commentator on the British common law, had concluded that freedom of the press meant there could be no prior restraint on publication. This meant that people had a right to publish what they wished, but that they could be punished for it afterwards. This is what Blackstone wrote. Liberty of the press consists in laying no previous restraints upon publications. But he continued, if a person publishes what is improper, mischievous, or illegal, he must take the consequences. In other words, although publication couldn't be stopped because it criticized the government, its authors could be arrested and prosecuted if the laws called for it. Now, this understanding of the First Amendment was confirmed by Justice Holmes of the U.S. Supreme Court as late as 1907. Note, too, that the words of the First Amendment are addressed to the Congress, not the states. Under the U.S. Constitution, the states were free to treat publications however they wished, constrained only by whatever limitations were contained in their own state constitution. This changed with the doctrine of incorporation, through which the court used the 14th Amendment to apply almost all of the Bill of Rights to the states. The First Amendment, for example, was held applicable to the states in 1931. Now, the Sullivan case grew out of the civil rights movement in the South in the 1960s. In February of 1960, a student-led sit-in movement had started in which African-American students sat down at lunch counters to protest racial segregation, and they refused to leave until they were served. On March 29, 1960, a full-page advertisement appeared in the New York Times. It was called Heed Their Rising Voices, and the ad was signed by 64 members of the clergy as well as other people of prominence. The ad complained that the police in Montgomery, Alabama had ringed the campus of Alabama State College and had padlocked the dining hall in order to intimidate the protesters, that Dr. Martin Luther King had been arrested 7 times, and that acts of violence had been directed at the protesters. It appealed for funds to support the student movement, the struggle for the right to vote, and the legal defense of Dr. King. In response to this ad, L.B. Sullivan, who was one of 3 white elected city commissioners of Montgomery, Alabama, sued the New York Times for libel, the printing of falsehoods. Although he was never mentioned by name in the ad, he maintained that the words police in the ad referred to him since he was the commissioner who supervised the Montgomery Police Department. And it turned out the ad contained some factual errors. The police had not ringed the campus, and Dr. King had only been arrested 4 times, not 7. In addition, in one place the ad alleged that the protesting students had sang "My Country 'Tis of Thee" on the state capitol steps when they had actually sung the national anthem. However, an all-white jury found the New York Times guilty of libel for publishing the ad and awarded $500,000 to Sullivan in damages. The New York Times appealed. $500,000 was a fortune in 1964, even for the New York Times. The lawsuit was part of an effort by the white leadership in Montgomery to destroy the civil rights movement. If the verdict was upheld, the New York Times and other newspapers and media outlets might be forced to stop accepting ads from civil rights groups, depriving the civil rights movement of a valuable fundraising tool. However, the Supreme Court overturned the libel verdict in a unanimous decision. Justice Brennan wrote the opinion, and early on he wrote the following: "We consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials." He dismissed the mistakes in the ad, noting that constitutional protection didn't depend upon the truth or the popularity or the social utility of the ideas and beliefs which were expressed. The court was particularly worried that requiring truth as a defense would lead to what it called self-censorship. If the verdict was upheld, Brennan wrote, people would not feel free to criticize government. This is what he said for the court: "The pall of fear and timidity imposed upon those who would give voice to public criticism is an atmosphere in which the First Amendment freedoms cannot survive." Now, did this mean that all libel law was unconstitutional? No, it didn't. It did mean that for a public official to prove libel, the Constitution imposed a strict 3-part standard. The standard was this: in order for a public official to win a libel suit, he had to prove that the statement made was, first, a defamatory falsehood, second, that it related to his official conduct, and third, and most importantly, that it was made with actual malice, meaning with knowledge that it was false or with reckless disregard for whether it was false or not. Now, in concurring opinions, Justices Black, Douglas, and Goldberg argued that the Supreme Court hadn't gone far enough in protecting the press. For example, Justices Black and Douglas argued that the New York Times had a, quote, absolute unconditional constitutional right to publish the advertisement. Now, the Sullivan standard of actual malice makes it very difficult for public officials to win libel suits against the press. It grants the press a great deal of legal protection for criticism of governmental officials. Although the language of the decision is really quite sweeping, one might wonder how much it matters. Many other democratic countries don't afford the press such constitutional protections, yet have robust political criticism. Further, it appears that the American people don't share the justices' passion for protecting the press. Even a decade and a half after the decision, when Gallup asked if the present curbs placed on the press are too strict or not strict enough, nearly twice as many respondents said the restrictions were not strict enough than said they were too strict. And it turned out one of the 3 main reasons respondents gave for wanting stricter curbs placed on the press was that newspapers published information that respondents said should not be made public because it is not in the best interests of the nation. Although the legal right exists, in practice the freedom of the press to criticize the government depends upon public support. The press depends upon the public for its livelihood, and without its financial support, its freedom of expression is constrained.
These next 2 slides are related to New York Times versus Sullivan, and it's just notes. And there's also a very small image of what that full page ad looked like. In my face-to-face class, I have a full-size image of that, which I'll put as a link in the lecture in Canvas for you. So please take a moment and look at this slide. So please take a moment and read this slide and the following slide. So you may want to pause the video to look through these. And this is the second slide in relation to some details about New York Times versus Sullivan. Please remember that the significance of this was the case that defined the term actual malice. And it was the first time it was actually used. L.B. Sullivan was the public official that initiated the suit. Check one, check. Sometimes opinion is expressed as parody, but is that protected speech? Hustler Magazine Incorporated versus Falwell is a 1988 United States Supreme Court case in which the court held that the First and 14th Amendments prohibit public figures from recovering damages for the tort of intentional infliction of emotional distress if the emotional distress was caused by a caricature, parody, or satire of the public figure that a reasonable person would not have interpreted as factual. Hustler was a gentleman's magazine well known for its sexual stories and visuals, but also for its stinging satire. To the contrary, Jerry Falwell was a Christian evangelist. When Hustler published this ad for Campari, although it was clearly a parody, Falwell was not laughing. After it went through the lower courts, it finally reached the Supreme Court. And in an 8-0 decision, the court ruled in favor of Hustler Magazine, holding that a parody ad published in the magazine depicting Falwell as an, incestuous drunk, was protected speech since Falwell was a public figure and the parody could not have been reasonably considered believable. Therefore, the court held that the emotional distress inflicted on Falwell by the ad was not a sufficient reason to deny the First Amendment protection to speech that is critical of public officials and public figures.
Hey guys, welcome to Hip Hughes History. We're hitting you up with some Supreme Court business today. That's right, the 1988 decision, Hustler Magazine versus Falwell. Yeah, hashtag creepy. Let's get to it. It's a famous First Amendment case, so I think I have a right to do it, but I'm warning you, it's a little bit gross. So, what a weird case this is. It's Hustler Magazine versus Falwell. Hustler Magazine, run by Larry Flynt, who's in a wheelchair. He was shot. It's a long story. It's a very, let's put racy publication as the title. Lots of nudie pictures, and also a lot of parody, kind of a lot of making fun of people using humor that really kind of pushes the line, if you want to say that. Almost in the spirit of like cartoon editorialists, but in a moment you'll find out why it's a little bit creepier than that. And they're going after Jerry Falwell. Jerry Falwell is the founder of Liberty University, a Christian university, and also the founder of the Moral Majority. He's a public figure who's advocating to fight against homosexuality. He's also very much pro-life and very kind of religious values, conservative, right-wing, and he's really loud about it from the pulpit. So in 1983, Larry Flynt, who runs Hustler Magazine, decides to do a parody campaign on Campari. I think I'm not pronouncing that right. Campari. It's a liquor. It's a drinky ad. And the drink ad had already existed, so they're going to do a parody. And in that drink ad, celebrities would kind of tell about the first time they had a sexual experience, but at the same time, they're really talking about the first time that they drank this liquor. So they're going to use that as the frame to run this ad. And this ad is Jerry Falwell talks about his first time, and I'm not going to go into the details, but basically he has sex with his mother in an outhouse. He talks about how she's better than a Baptist whore with a $100 donation. That was in the ad. I didn't say that out loud, kids, from my mouth. That's from the ad. But then it goes on to say that he continued this incestuous relationship with his mother, and that at the end, kind of the punchline is they ask him about the first time he had this drink, or does he drink this drink? And he goes on to say, how could I, rattle off all that bull beep at the pulpit if I wasn't drunk? So that's kind of like the punchline. But after that ad runs, Jerry Falwell is very hurt. He's very sad. He's emotionally distressed. So he's going to sue, and now we're going to go to court. Are you ready to go to court? Let's go to court. So originally, Larry Flint is claiming New York Times versus Sullivan. And in the New York Times versus Sullivan case, which defines what libel is when you kind of intentionally slander somebody through the newspaper by not only, and this is what the court says in New York Times versus Sullivan, that it's infactual. You know what you're saying is wrong. Is infactual a word? But that it's done with malice, that you have an evil heart, that you're going after somebody and you're lying about them. That was a Martin Luther King case. But at the end of the day, what Larry Flint is saying is nobody thought that this was factual. This was a parody. And if this was a parody, then even if it was with malice, let's say I did intend to emotionally harm the guy, then it's still good because nobody really is thinking that this is the truth. And in the lower court, the jury agreed that this wasn't libel. They said this wasn't libel. Everybody knew it was a joke, but poor Jerry Falwell, we're going to award you, I think he got $150,000 for emotional damages. So really what Larry Flint is asking the court is to take kind of this New York Sullivan case. And Larry Flint is saying that the New York Times versus Sullivan case should apply when it comes to public figures dealing with emotional distress. And the court agrees. This is an 8-0 decision. And in the Rehnquist court, you don't get a lot of 8-0 decisions. It's a huge win for free speech. And what the court says basically is they say, if we have this rule where if you're joking around and making fun of somebody, and they can, claim emotional distress, this would have a chilling effect on free speech. Think about editorial cartoonists, people exaggerating noses and features and poking fun in order to get a political point across. And sure, Larry Flint really kind of took it to the extreme here, but as long as that's guarded by the First Amendment and that ad wasn't claimed to be obscene in terms of First Amendment standards, then public figures can't claim emotional distress. So in a sense, what they're doing is they're taking this New York Times versus Sullivan ruling and they're applying it to public figures when it comes to emotional distress. So you can go after them. If somebody's a public figure and you want to go after them, as long as it's a parody, you're not like purposely saying, look, this politician does heroin. And he doesn't do heroin, that's a different story. But if you're doing a parody, a joke, satire, you're poking fun, and it's, very obvious to the reader that that's what you're doing, then boo-hoo-hoo, you can't sue if you're a public official. Because they say, look, this guy's a public official, he's making statements related to public policy, and it's free rein then. If they want to make a political statement using this type of humor, go for it. So a big win for the First Amendment. I guess you guys can go get your draw pads out and make funny pictures and stuff of public figures now. How about that? And they can't sue you. So there you go, guys. First Amendment, it's a win. Hustler Magazine, it's still a little bit creepy. Side note, Larry Flint and Jerry Falwell eventually became friends. How about that? Discussed philosophy, exchanged Christmas cards. What a cray-cray world we live in. So there you go, guys. Thanks for watching another Hip Hughes history video. We have over 300 videos.
So a question that I'm asked often is, at what point does a statement of opinion become unacceptable and really truly become defamatory? And that was addressed actually in this next case that I'm going to talk about. But before I tell you the name of the case and tell you about it, I want you to understand that what the justices determined was an opinion is defamatory if a reasonable jury could find that the opinion implied a fact concerning the defendant and the implied fact can be proven false. The case initiated in Lorain, Ohio in 1974 at a high school wrestling match when there was a fight or a brawl after a match between two teams. It was right before the state playoffs, and if you've played sports, you know how how exciting it is when you reach that point. Unfortunately, both teams were placed on probation and were told they would not be able to go to the playoffs. Well, parents weren't happy, players weren't happy, etc. And it went to a local court that decided to remove the ban, and the coach testified under oath that there was no brawl. So the local paper was the Lorain Journal, and there was a reporter named Ted Didion who wrote an opinion piece in a sports column, and he implied that the coach lied to the judge about the brawl, that he committed perjury. So right there he's accusing him of a crime. Well, The coach, which was Mr. Milkovich sued the newspaper for libel. That happened in 1974. It went through the courts and was appealed several times until it finally reached the Supreme Court in 1990. And this is what the justices said was, in some circumstances, opinions may often imply an assertion of objective fact, especially when it involves criminal activity. So hence, the the reporter should not have made that assertion of fact that he committed perjury on the stand because he couldn't prove it. This reporter, if you'll see my note here, he had a 16-year court battle. And journalists need to be extremely careful. I should say, people who work in media communications need to be extremely careful of their word choice when in a situation like this so that they don't cross that line between opinion and libel. So I'm going to take a break here, and the next video will be about the torts related to invasion of privacy.